and welcome to the session on Public Procurement Framework. Now, under this framework, the learning objectives which we're going to cover is first is introduction to government organization and public procurements. Second, we're going to talk about the role of government in procurements, framework for public procurements. If you recall the module 1, I did talk about the framework, the broad guidelines. So the framework was talking about the module, manuals, guidelines are the way GFR you are known. Legal implication of public procurements, legal aspects of the Sale of Goods Act, and lastly is going to talk about arbitration and conciliation. So broadly, when we talk of a framework, we're talking the objective is to mitigate the legal risk and ensure compliance. So you know very well when you're doing signing of a big contract, potential is there. There could be legal risk, could be protest from a supplier, could be the goods which were supposed to be delivered were never delivered in time. All this leads to legal disputes. And the next one is, since the public money, there's a need to ensure compliance. The rules are followed, the procedures are followed, the key principles are followed. That means the competition was on a level field. No favorism to X and Y. That's what we look at the compliance. Now let's get down to the government organizations. If you look at the government, there are three bodies around. One is called legislature, executive, and judicial. Now, we know very well when we talk of legislatures, they are right to make laws. If you talk of contract law, the contract law dates back to 1872. If any amendments have to be done, changes have to be done, obviously that's the job of the legislatures. All government work is done through various ministries, departments. The people who are placing orders, the people who are buying resources, who are outsourcing functions, those are the executive branch around. And if you look back after independence, we didn't have much of industries, whether we talk of Hindustan Steel, whether we talk of airlines. So naturally the government has to promote development activities around, so they have to come up with PSUs, public sector undertakings, because there was hardly any private sector investment. So in the beginning there were a lot of PSUs, so they were also there, and they are under the control of various ministries. When we look at public procurement in India, as I said in the first module, government is the biggest buyer. So when I said to you around 25% of the GDP, close to around $50 billion yearly, what do we do with this money? Some ministries are defense, railways, CPWD, urban developments, all the highways, schools, health, they cover up all these funds around. And some PSU. I mean, most of the PSUs are supposed to cover their own cost. But there are some PSUs, they depend on the government, so some funds goes there. And PSU also, look at BHEL. If the turnover is around $4 billion, out of $4 billion, the procurement activities could be around easily 50%. So procurement becomes a major share even for the PSUs. Many large ministries have set up their own procurement organizations. Government has also central procurement, what's called DGS&D, Directorate General of Supply and Delivery, which buys on behalf of other governments. Some of the government doesn't have the capacity, they give the work to DGS&D. The DGS&D job is basically to do the strategic procurement. So they basically see, okay, these are items which are bought by everybody, which are the common user item. For those common user item, they try to negotiate the price, so everybody doesn't have to bid for it. You can imagine if each state is buying, their volume is smaller. But if DGS&D can compile all the volumes, get a volume discount, which everybody can take benefit of it. That's what the role is. In addition, state governments are there, public sector undertakings are there. They all undertake public procurement, it's public funds. Each one of them have their own guidelines, but they're all based on the guidelines of the Government of India, that is GFR. So GFR is a guiding factor. So based on the GFR, everybody might have developed their own further manual how to do it. Framework for public procurements. So framework, when we talk around, it has got three pillars. First is obviously the academic framework, the professional framework, where we talk around that the benefit should go to SMEs. We should not worry, we should not hire the children's, we should not be differentiating and all those things around. We should be given a fair chance, level field. Then we need a legal framework. Obviously, contract means there's a risk. Risk means there has to be legal issues around how to handle the legal part. So there has to be legal framework, the terms and conditions, the right interpretation of each and every term. If interpretation is not spelled out, everybody will interpret in their own ways. Central government's framework. So we have the central government framework, which is there from the central government, GFR. But then each state develops their own. I remember I had a chance to work for Mizoram government. So they have developed their own procurement manual. So even their own guidelines, but they are based on central government framework. Now, legal framework is the next one, which is very important for all contracting issues. Now, here we are going to talk about public procurement law. There was a law which was supposed to come up in 2012. It's still going on. In this law, the focus was to make procurement as a profession, certified profession. So the moment we make it a certified profession, everybody who works in procurement has to get some certification. The purpose was to improve the professionalization. Still, that has not been done. I think we are the only one in the South Asia who doesn't have public procurement law. We do have a contract act, so don't mix up this with contract act. So we have a contract act of 1872, but procurement law, which has to broaden the principles, improve some professionalizations, how to handle emergency procurement, those have not been still spelled out. Then there's a mercantile law. You're selling goods. So those selling of the goods from one to another, they come under the Sales of Goods Act. Now, central government procurement framework, if I look around, is to regulate, monitor, reform, and professionalize. We have, all of you know very well, Central Public Procurement Portal, which has been set up. And that is the purpose, is to ensure transparencies. In this portal, if I have to do any procurement in the government, they have to be posted there. Every major contract has to be posted there. Even the state governments are expected to post there. So in the process, you are ensuring a transparency that anything above the X amount has to be informed to all. Then we have Comptroller and Auditor General of India. We have Vigilance Commissions. We have framework for grievance redressal. If there's some grievance, any supplier has got around how to handle it, we have the framework. Then we also have framework for best practices. So the best practice means which rule to follow, what guidelines to follow, what manuals to follow. So these are all part of the legal framework which we have around. Then we also have GFR of 2005, and the GFR covers principally the fundamental principle of public buying. As I said in the beginning, the principle is competition, competition, competition. Fair chance to everybody around, level field for everybody around. Methods to maintain transparencies. How do we ensure transparencies? As in the previous slide we have shown around, one is that every contract above a particular amount has to be posted on CPPP, has to be advertised in the medias around. Procurement of civil laws, civil works, hiring of consultant, how do we hire the consultants? Inventory management, how it is done. Contract management, how to be done. So all these are spelled out in the GFR as a guideline. Since GFR is covering the fundamental principle, so these are amplified into 3 manuals of the finance ministries to cover goods separately, services separately, and work separately. So when we look at the legal implication of public procurement, procurement contract, besides being a commercial transaction, is a legal transaction. You're placing a contract, yes, one may call it a commercial, but it's also legal. Legally means you can be dragged to the court. Now, there are a large number of laws to cover the various commercial transactions. Procurement profession is expected to have working knowledge of the following. Some people may think, guys, this is not my job to know the legal side. The legal side is covered by my lawyers. But since you are dealing with it, you are making the POs, you are making the contract, you need to have a good understanding of the legal side. So again, here I would say one is Indian Contract Act of 1872, which is based on English common law. And some other country they follow civil law. That's in like France, they follow civil law. But all the Anglophone countries where the British were ruling around, they're all based on English common law. Then we also have Sale of Goods Act of 1930. Then we also have in India Arbitration and Conciliation Act of 1996. So any legal disputes will fall under these 3 acts around. Introduction when I talk around is contracts are basis of all daily activities around. When we make a POs, the supplier accepts it, the contract is formed. So if you are not having a contract which is legally enforceable, you're working on a verbal understanding, there's no contracts around. Naturally, if there's a dispute happens or something goes wrong, this could lead into troubles. So I would say that every contract of particular about some threshold, there has to be a written contract. So contract is nothing but, obviously there has to be an offer, there has to be an acceptance, there has to be consideration. So without consideration, you can't have a contract at a 0 values. Even when you're hiring somebody, the guy, I won't charge any money, I'll do free. There also you make a contract of a $1 or 1 rupee. So consideration has to be there around. Without considerations, some people say, oh, I work on a pro bono basis. So pro bono is, yes, wonderful, but pro bono also contract has to be spelled out. $1 or 1 rupee depending on the currency we work on, there has to be there. Offer and acceptance has to be mirror image. It should not be there, I accept it subject to blah blah blah. The moment you say subject to, it becomes a counter offer. So counter offer means then somebody has to again revise the offer. So offer and acceptance we call them as a battle of forms. So that battle goes on till both becomes a mirror image. Now when we talk of legal issues, one has to know how the contracts are formed, contract implementation, how do we ensure the implementation, securing the contract performance. Guys, you have signed a contract of a big amount, you are not sure whether the contract will work or not. The guy is going to follow the milestone, the guy is ensuring a good qualities. Termination remedies. Sometimes you have to terminate for some reasons. One could be that you don't have a budget. Funds have been stopped. So naturally, when the funds are stopped, you want to terminate. Second, it could be that you are frustrated with the supplier. Like you and me get frustrated with somebody, contract can also become frustration. You're sending tons and tons of messages to supplier. Supplier is not bothering. Supplier is not doing as per the plan. You're not happy with the quality. The guy is not responding to you. That's what we call the frustrated contract. So once the contract gets frustrated, you want to terminate it. Sometimes what happens is supplier also wants Remedies. There's a breach. Supplier has told you that they will do the job by this date. It doesn't happen. There's a breach. So when there's a breach, I'm not saying breach on the supplier side, the breach could be on the buyer side also. Buyer has promised them the payment would be done in 30 days. It doesn't happen. There's a breach. So whenever there is a breach around, there has to be remedies. So those remedies have to be spelled out. Terms and conditions. So what are the terms and conditions of contract? And last is, how do we draft the contract? You may be having a standard templates around, but those need to be revised case to case. One size does not fit all. Another issue which comes up is applicable law. What is the law applicable? Let's say I'm buying the goods from another country, let's say Hong Kong. Is the Hong Kong law applicable? Or is the Indian law applicable? I'm buying from the US. Is the US law applicable? Is the Indian law applicable? Is it the person who buys, is they dominated? Or the supplier, they dominated? All that applicable law we have to talk about. Now, invitation to make an offer. So you try to invitations to make an offer. So you have standard price list sometime. You are inviting somebody. Somebody sends a beautiful catalogs to you. They invite you to make an offer. Go to the department store. Things are displayed nicely along with the prices. So they are trying to invite you. They're trying to create attraction in you. Come on, make an offer. They show a beautiful dress. They say 50% discount. So they are trying to make an offer to you. Now comes to contract formation. So offer is a beginning. Keep in mind. Offer is a beginning. Somebody has to accept it. Then the contract is formed. As you go to the department store, somebody is displaying outside a dress. You like it. And you say, guys, I accept it. You go to the counter. There's an offer already there. Acceptance is there. Contract is formed. So contract formation is there. So there has to be invitation to offer. And then acceptance around. There has to be agreement on both sides. And the next thing you have to also avoid, the battle of form, as I said to you, is mirror image has to be there. And then you can revoke the offer. You have made an offer. Then suddenly you get a beautiful idea, guys. No, I did a mistake. Now you want to revoke it before the guy starts making it. Let's say you send me an offer and I have got the offer and I've already started buying the raw material. Now you want to revoke it. I'll say, guys, yes, if you want to revoke, you'll have to pay the money which I have spent on the raw material. I've already committed. But if you can revoke before the POs comes to me, then yes, there's no penalty on you, there's no liabilities on you. Now the definition of offer is, offer means you are giving, like a purchase order is an offer. The very specific terms are there, very definite. And you also mention, upon acceptance by the offeree, the offer will be bound thereby. There's a binding effect. That's why sometimes you send a supplier, at least in the public sector, very common around, you want supplier to accept it in writing. In private sector, we allow, even if they don't sign it, we'll say by work, by conduct, they accept it. Next come the rules with respect to offer. Now, offer is not required to be in any particular form. Offer could be by email also. It's not necessary it has to be beautiful PO format. It's a standard format, but it doesn't mean it has to be particular form. So if you are committed and you are authorized to send it, you are saying, guys, okay, I hereby authorize, please go ahead. Other guy sends a message back to you, noted, and I'm working on it. The contract is formed. The person who makes the offer is called offerer. The person to whom the offer is made is called offeree. So keep in mind there's an offerer and there's an offeree. Now offer can be made to one or more persons, even the whole world. So all terms of an offer must be communicated to the offeree. So when I said in the third bullet, I'm sending a catalog, like Flipkart is sending a catalog to everybody. They're giving their offer to everybody. So people can go online and accept it and the contract is formed. So you could give the offer to the whole world or to more persons. Termination of an offer. Offer will lapse if acceptance is not made within the time stated. As I said to you earlier, offer can be revoked before acceptance. The guy has still not accepted it, but you're revoking it. Offer will be terminated if rejected. Death of the offerer or offeree. The guy who's giving the offer, if that guy dies, obviously the offer is gone. Similarly, offerer and offeree, any one of them, it leads to termination. So these are the situations, termination of an offer. One is you reject, you make a conditional offer, and then second is a lapse. You made an offer and you told them, guys, I want acceptance within 1 day, within 24 hours. If no approval comes back, it lapses. Death we talk about. You could revoke it, guys. I'm trying to revoke it for many reasons around. So that's very clear. Termination of an offer, I think already I've touched those points, so I can skip this. Now the parties to a contract, there are offerer and offeree. Offerer makes an offer. Offeree has the power to accept the offer and create a contract. So you can see it around, there's an offer and acceptance. Finalizing the agreements. So naturally now you're coming to the negotiation stage with the vendors. Department approvals required. Additional necessary approvals are required before agreement becomes a contract. Now elements of a contract are, there has to be an agreement, contractual capacity, there has to be consideration. So agreement is formed, there's an offer and acceptance, agreement is formed. Like I tell my friend, okay, I'm going to see you there today in the picture hall. Agreement is made. Or you could say, okay, I'm going to sell you 100 computers, the price is fixed, agreement is made. Now agreement is made, but consideration has to be spelled out. So if without consideration, agreement is just very loose. Contractual capacity. The people who are saying yes and no, they should be legally have authority. In every company, there are people who are authorized to contract. Every person has no legal authority to sign. So there has to be contractual capacity. And the last point is lawful object. Whatever you are buying, if it's legally not allowed, like buying of ammunition, buying of drugs, they're legally not allowed. So those contracts, even if you've gone through agreement, considerations, contractual capacity, since legally it is not allowed, contract cannot be formed. If the contract is not formed, you can't make other person accountable. So consideration, as I said to you, but keep in mind there's a difference in contract versus gift. Now, prerequisite of an agreement, you have to keep in mind agreement should not be under threat, should not be under pressure. Somebody comes and puts a gun on your neck, guys, sign it. That agreement, that contract is a fraud. Undue influence, fraud, misrepresentation. Somebody has given you wrong information. They're represented wrongly. So those type of agreements will lead to null and void contracts around. TNC of the contracts, we talked about liquidated damages. If the time is a sense of the contract, then you try to spell it out. You can't penalize without liquidating the damages. So you have to liquidate your damages upfront. Guys, if it is a delay by 1 week, I'm going to charge you 0.5% of the values. And every week I'll charge you 0.5%. If it becomes 10%, I will terminate. And after termination, when I go to the second supplier, and if second supplier price is higher, you will have to pay for the compensation. Force majeure is the act of God, war, government actions. Suddenly government decides that we're putting a sanction for all the supplies from X and Y country. And you have placed the order already with that country. So naturally, you can't buy from there. Modification of terms and conditions. Conditions and warranties. So there are warranties and conditions. Now the law of the agencies, agent means the person who can enter into contract on behalf of the principal. So the principal person is away, and now that principal has put somebody as an agent to sign on his or her behalf. But keep in mind, agent has no liabilities. Let's say if somebody is the head of the company, the guy is going away, they give authority to someone to sign on his or her behalf, that person becomes the agent. But if something goes wrong, and if they're done in a good faith, agent cannot be liable. And if you take precautions, call for authority of the person submitting offers. Sales of goods acts. So when you're selling the goods in your day-to-day transactions, so this act works around. Incoterms, very, very important around. When we're doing shipping, internationally or locally nowadays, both. Earlier it was only for international. If you look at the word IN, international, commercial terms. But now this can be used for domestic also. So when you're buying goods from X and Y place, on the way something happens, who is accountable? The ship is coming, ship is sunk, the goods are thrown into the water. So naturally, who's accountable? So these Incoterms, which is called Incoterms 2010, they answer to most of these queries which comes around. Who will take care of insurance? Who will be liable? Who will be doing this various activities around? Now here it comes a little bit on the steps of the logistic part. Obviously you're doing packing, loading, you're doing transportations, custom clearance, handling outbounds, insurance, main international transportations, custom clearance, and so you can see from the country which is being exporting and the country where it has reached. So that shows you the complete step of global logistics. I think this is good to know, and the Incoterms addresses most of this around. Now the Incoterms which happens around, obviously the one is Ex Works, which I'm sure you all know. You and me, when we go to the department store, I buy a fridge, I buy a washing machine, they're all Ex Works. When I come out, if my car meets with an accident, I can't go to the shop, oh, your car has met with an accident, give my money back. So once you're out, your responsibility is yours. Free carriers, carriers paid too, carriers and insurance paid too. But when we talk of carriage and insurance paid too, SIP, the supplier is taking care of insurance on your behalf, but the monkey lies on your head. So you have to worry around that part. Delivered at terminals, delivered at point, place, and the last is DDP. There are others also we use for the shipping purpose. FAS, FOB, CFR, CIF. So if you're sending the goods only by water, then this one. But in today's world, we use multi-channel. The items are coming by truck first, then by train, goes to the port, from port to port, then unloaded at the port, then goes into the truck, goes into the train. You can imagine wide range of mode of transportation. So the shipping documents changes accordingly. This is another one, the Doctrine of Caveat Emptors. This is very outdated, old ones. See, particularly the buyers to be aware that they must act with due diligence. Suppliers can conceal the defects and get approval from the buyer. Condition as to descriptions, they have to be fit for use. Condition has to be merchantable. Somebody is giving you, you're buying a pack of let's say apples or something, on the top the apple look good, but you expect the supplier is giving you the food or anything around, they are fit for use. They are merchantable. They are wholesomeness. So these are implied in one way. Even if you're not spelled it out, they are the implied condition when you buy many food items. You're not going to spell it out each line by line. So these are implied, they are covered under this doctrine. We have this one CISG, which is developed by United Nations Convention on Contract for International Sales. See, you have your own sales acts around local, but when you're doing internationally selling around, you're sending a goods from here to another countries around. Those countries are part of the CISG. They have ratified CSG. They can use it as a part of sales of goods. Then we have Arbitration Conciliation Act. And this Conciliation Act is there. These are based on UNCITRAL. Now, UNCITRAL is all about arbitrations. So this is the oldest method of settling civil disputes. See, you have a dispute. One is that you can go for litigation. Litigation means you go to the court, and this could take you ages and ages before you could come with a solution. So most of the MNCs or the big companies, they can't afford to wait. They put down in their guidelines, if there's a dispute, we'll go through arbitration. And that arbitrations is done with the local guidelines. And MNCs normally uses different, like in Singapore, those guidelines are used around. So arbitration, as I told you, the person appointed by the are called arbitrators, and they make up. This is must between the parties to follow the above course. There's an arbitration agreement. You make an appointment, you make the composition, and based on that, the work is followed. Now there could be challenge to the appointment arbitrator. Somebody has decided arbitrator, but there could be challenge. So based on that, the action could be taken. Conduct of arbitral procedure. The language and the venue can also be decided by the parties. If both the parties are based in India, they can decide the language and the venues. But if the arbitration is going on in the other countries around, as I was telling you, many MNC use Singapore as a venue. So we have to work it out. The language and the venue has to be spelled out. Arbitral award is there around. Recourse against, you can still have a recourse, but within 3 months. If it is more than 3 months, then you can't go any recourse around. This is the next concepts around conciliation. The party initiating conciliation send invitation to other party. Proceeding starts after acceptance by both the parties. It is fundamentally different than arbitration. So assist the party by driving the negotiation and directing them towards the satisfactory one. This works out to be economical, faster, but sometimes very difficult to have conciliation, very high value contract, complex contracts around. Now the terms and conditions which comes up around the legal status of both the parties, source of instructions, who's authorized to give instructions, contractor's responsibility for employees. Then when we have given a contract to suppliers, they have a responsibility to ensure a good working condition for the employees. You may remember the case in Bangladesh. One of the famous companies has given the contract for making the shoes. Then there was a suddenly fire, but it spoiled the image of the main company. So they expect the contractor is going to give a good working condition and safe conditions. Assignment. You've given a contract to someone, the guy doesn't do anything except assigns to someone. You need an approval. Subcontract. I take a work from you and then I subcontract to someone, not the whole thing, but some part. I need approval from you that I'm subcontracting to so and so. Official not to benefit. It's very important around. Officials who are involved in the chain, they should not get any benefit. Indemnification, that you have to indemnify the buyers. If Government of India is buying it, they will expect that their buyers are indemnified for any claims coming from third party. insurance and liabilities to the third parties. So these also have to be addressed. Well, friend, with this, I want to thank you again all for the patient hearing. And still, if you have any questions, you can send us. But we have two poll questions. So I will request if you can answer